Hello and welcome to this week's presentation from Hendricks Wealth and Estate Management. The topic for today is estate planning in retirement years. I am your host, Sean Hendricks. Just a little bit about me. I am a financial advisor and attorney with Hendricks Wealth and Estate Management. I've been doing this for quite a while now, actually. I had law license in 2009. I passed the Series 7 back in 2012. I took the Series 65 in 2019. And so I've been doing financial advisor and attorney work for quite a long time. To talk about today's subject, estate planning in retirement years, I mean, most people are familiar with the basic concepts of estate planning, right? You're essentially leaving a set of instructions for here's what to do with my stuff when I pass away. But less than half of people in the United States have an estate plan. Today, we're going to talk about why it's so important with a particular emphasis on estate planning in retirement years. So when I talk about an estate plan, people are familiar with the basic concepts. I'm going to use some terms during this presentation, so I want to talk about those a little bit. And here are some of the basics. We might be talking about a will, a trust, a power of attorney for healthcare, a power of attorney for property, making beneficiary designations on accounts that allow them, and some other types of documents, including or not limited to using a living will or an advance directive, a type of document called a transfer on death instrument, a remembrance and services memorandum, or just maintaining a list of accounts and other important information like financial information for your trustee. These are all things that can be very important. So I may use these terms and I'll define them a little bit as we go along, but these are going to be some key terms to look for. Regarding why estate planning is so important, right? Why, especially in retirement, when a person passes away, one of two things happens. Either they leave some sort of a plan for dividing their assets or they don't. When you leave a plan, either through a will or a trust, that plan will generally be followed. If you don't leave a plan, attorneys sometimes refer to that as being intestate or following state law of intestate succession. When you leave a plan, it's your plan. Intestate succession is by function of the law, and it might do what you want, but it might not do what you want. And a lot of times with intestate succession, especially if you own real estate or if you have more than a certain level of assets that varies by state, you're going to end up in probate. So leaving a plan allows you to control who gets what, and with some advanced planning, it will likely make the process much easier on your loved ones, and you might even be able to avoid the probate process with your estate. So all of those things could be very important. So the different options that we're going to present, and I'm going to talk about kind of 4 different options that are pretty common or that I sometimes see. And option 1 is kind of the tried and true, the thing that's been around a long time, which is using a will as the centerpiece of your estate plan. So using a will is, and most people are familiar with this concept, and when you draft a will as the main document of your estate plan, it's essentially just a set of instructions. Here's what to do with my stuff when I pass away. A will itself doesn't just make that happen. In order for a will to control what happens with your stuff, it typically has to be submitted to the court through a process called probate. So the instructions for the division of assets is good, right? You're leaving a plan. The part that might not be so good is that if you have to go through probate, some people don't want to do that. Probate can be very time consuming and expensive. So how the process actually works is when somebody passes away, when they use a will, the will gets admitted to the court system through the probate process. A judge creates a temporary legal entity, the estate of John Doe, the person who passed away. Once the estate is created to temporarily hold the property, that temporary legal entity to hold the property, the judge then will issue an order putting the executor in charge of the assets. All right, it becomes the executor's job to do what it says to do in the will. After that process begins, there's a time period where creditors are allowed to make claims against the estate. That in Illinois, that time period is typically 6 months, but that can vary in other jurisdictions. Once the creditor's claims are recognized and paid, an accounting is prepared on behalf of the estate, showing all of the assets and liabilities of the estate. Once everybody agrees and the court signs off, then the assets get distributed. And this process from start to finish, a lot of times can take 12 to 18 months or sometimes even longer if there are any hiccups in the process. So using a will is good because it does leave instructions for the division of your assets, and it's making sure that what you want to happen happens. But it can be time consuming, and probate can be kind of inefficient and expensive. So that's something to really think about if you want to willingly submit to that probate process. Something that a lot of people don't understand when they're trying to decide between whether to use a will or the next slide, we're going to talk a little bit about trusts. As we sit here, as you and I sit here, we are legal entities, right? And in United States property law, property typically has to be connected to a legal entity. Now, either that's to an individual, right, because we are legal entities, or other legal entities can be things like LLCs, right, companies. Companies are legal entities, or trusts. Trusts can be legal entities. So when you use a will, you're essentially saying, hey, my property is going to be attached to me. And while I'm living, I control my property, and I'm going to decide what to do with it. The problem is that when you pass away, you cease to exist as a legal entity. That's why the court needs to step in. The court steps in and creates this temporary legal entity to hold your property, the estate of so-and-so, the estate of the person who passed away. So when we're using a will, we're essentially saying, hey, my property is going to be attached to me while I'm alive, but I'm going to proceed in the knowledge that when I pass away, we're going to need a temporary legal entity created by the court to hold that property until that property gets distributed to all my beneficiaries or my heirs. So that process, that probate process, is where the court is creating that temporary legal entity, and that process is generally overseen by the court, and the judge will issue orders moving that process along. If you don't want to do that, if you want to avoid probate, you can use our next option, which is a trust. And trusts are becoming much more popular. Back when I first started practicing law, wills were still more common. I would see about a 50-50 mix of people wanting wills and people wanting trusts. But the needle really has been moving more in favor of using trusts in recent years because a trust can avoid the time and expense of probate. And it can make the estate administration process easier for the beneficiaries, especially when the beneficiaries and the trustees are the same people, right? They're the people who have an interest in making sure that the estate gets reconciled. So how a trust actually works is the trust is created. The person who creates the trust can have a lot of different names: grantor, settlor, trust maker. Those are all synonymous. They all generally mean the same thing. It's the person who creates the trust. Once the grantor is the term I'm going to use for this presentation. Once the grantor creates the trust, they have created this new legal entity, the John Doe Trust. Because the grantor is creating that legal entity in advance, they eventually put property in it. Now there's a legal entity that can survive you, and we don't need the court to step in, as long as everything that needs to be in the trust is correctly put into the trust. So we create this legal entity, the John Doe Trust in this case, and then the grantor transfers property into the trust. So now we've got a legal entity that's potentially separate from ourselves that can hold property for us even if we pass away. So we transfer property into the trust. When the grantor passes away, or the grantors pass away, if it's a joint trust, we don't need the court to step in anymore. We've already created the legal entity, the trust, to hold our property for us. Debts are paid from the trust, typically, just like with a will. So there's typically an instruction that any valid debts have to be paid. Once the debts are paid, the final accounting is completed. What are the assets and liabilities of the trust? Once it's agreed upon, everybody signs off that everything looks good. The assets are then typically distributed from the trust. And the reason that a lot of people like trusts is because they can be administered much more quickly, especially if you have a motivated trustee. We don't need to wait on the court to issue orders. We can take all of the assets of the trust. And for a lot of people, what might be in the trust? There might be some liquid assets, savings accounts or investment accounts. There might be a house, that's pretty common. And the limiting factor might be how quickly the house can be sold. Meaning once the house is sold, that asset is converted to cash. We include that in the assets and liabilities of the accounting that we've prepared, and then everything can be distributed. That can go a lot faster because we don't need the court to issue orders and we don't need to wait for certain things to happen. So that shorter time period can be more efficient, and it can also save some money. So the probate itself can be pretty expensive and time consuming. So if trusts are more efficient and they can save some money and they can happen privately, sometimes people really like the idea of how a trust works. The third option is not one that I really advocate for because I'm an attorney. I don't really advocate for having no plan and just relying on intestate succession, because it does leave a lot to chance. Most people, if I walked up to a person on the street and said, hey, what happens under intestate succession? A lot of people might say, into what? Into who? I don't even know what that is. And so you're leaving a lot to chance if you're not familiar with how intestate succession actually works. So when someone does not have an estate plan, if they pass away and they have no estate plan, someone, and it's a lot of times this is a family member or someone who's close to the person who passed away, will initiate a probate proceeding in court. The court will then appoint a person to act as the executor or the personal representative over the estate. And again, a lot of times this is someone who's close to the person who passed away. The debts are paid just like usual. So we get an inventory of the assets and the debts. We complete the accounting just like when someone has a will, and then assets are divided according to whatever state law says to do. Now, sometimes that might be close to what you want, but sometimes it might not be. And because this might be viewed in multiple states, I'm not going to get deep into state law because it can vary. But this process still takes, can take 12 to 18 months. And this is a situation that's ripe for disputes, right? This is right where you might have a situation where like, oh, mom and dad told me that they wanted me to have, the car. Well, there's nothing in writing. Sorry, that's not legally enforceable. So it's just it's leaving a lot to chance, and I'm not a big fan of allowing disputes to arise or leaving things to chance for that reason. So intestate succession, half of the country is relying on it. I don't think it's a good first option. I really think I would really want people to have at least a will, so that their wishes are reduced to writing and signed and done correctly. The fourth option that I see sometimes is what I like to call the DIY plan. And sometimes people will do this, will try to do kind of estate planning on their own. They'll try to do some like ad hoc estate planning, where it involves them using a mix of beneficiary designations on accounts that allow them. So, for example, like putting beneficiaries on retirement accounts, which I think is a very good thing. But then instead of using a trust or a will, they will sometimes use something called a transfer on death document, or a TODI, that would allow their home to be transferred to certain named beneficiaries. And so what they're hoping is that if they put enough beneficiaries on everything and they transfer their home using a transfer on death instrument, and this has different names. It's a transfer on death. I've even heard of it called like a ladybird deed in certain states. It has all sorts of different names, but the transfer on death instrument on the house is really just adding beneficiaries to a house. So they name beneficiaries on their retirement accounts, which is good. They file a TODI or a transfer on death instrument with the county recorder where the house is located. And a lot of times they'll just name their kids, right? They'll name their kids as the beneficiaries of the house. They then hope that between their beneficiary designations and their house being covered, that their remaining assets are not enough to trigger probate. This may or may not be the case. Different states have different rules on this too. And if the assets go above the threshold for probate, then you're going to probate anyway, and all of the things, all the steps that you took are kind of rendered moot. So how the DIY plan can go wrong is that not all states allow transfer on death instruments for houses. So if you live in a state like Illinois and you are relying on this plan, and then you go and move to a state like Florida, well, Florida, as far as I know, does not allow TODIs. So your estate plan that you were planning on using in Illinois might not be valid in the state that you're trying to move to. The other thing I'm not crazy about is when you use a transfer on death instrument for something like a house. You're saying, let's say you have 3 kids and you name each of your 3 kids equal beneficiaries. Well, they're inheriting a house, meaning you now have 3 separate owners of that house upon your passing. And 3 separate people now have to agree on what to do with that house. And if you have 3 people who all have to agree on the same thing, that can lead to fighting. And fighting is generally what I don't want. I try to steer people away from situations where fights could happen. And so you have 3 people who all need to agree, and you have 3 people who may need to attend a closing and agree on the sale price. It can be a lot. I generally don't like having 3 decision makers when one is a better option. And when you use this plan, you still can end up in probate. If you haven't covered all of your bases, you're going to end up in probate anyway. So the DIY plan, I've seen it work, but I've seen a lot of people try to set it up, and I've had concerns that there were some things that they didn't know about that could cause them, or could have or would have caused them problems. So why are these things, why is estate planning so important in retirement? Right? Well, the main reason is a well-constructed estate plan is really more than just a set of instructions as regarding who gets what, right? That's what it is at its most basic level. But an estate plan can do a lot of other things. It will name the person who can make healthcare decisions for you, whether this is a power of attorney for healthcare, or sometimes it's called a healthcare surrogate. This arguably could be one of the most important decisions you ever make. Who is going to make end-of-life decisions for you, potentially? Who's going to give instructions about what kind of care you can receive? Who's going to be able to communicate with your doctors if you have to go into a nursing home? This is very, very important. The other side, the flip side of that coin, is who could make financial decisions for you. This is a document often called a power of attorney for property. Or if you have a trust, it might be the trustee under your trust. This is important because you are trusting this person to make sure that your estate is taken care of in your absence, right? And again, in the most common use case scenario, if someone developed Alzheimer's or dementia, who would be the person who could make financial decisions for me? Now, a lot of times that person by default is their spouse, right? But after the first spouse passed away, now there's a real question there as to which of your children, if you have children, would make those decisions for you, or if you don't have children, then who is that person going to be? And you might have some specific wishes, and unless you have these documents set up, that you're leaving that all to chance. A well-constructed estate plan could also allow someone to start or continue a gifting strategy from your estate. And this is important because if you are above any state or federal estate tax thresholds, then starting or continuing a gifting plan might be really, really important. It could save your estate lots and lots of money. So a power of attorney for property or your trust or both documents working together could give someone the power to make these strategic gifts. It could also, a well-constructed estate plan could allow you to engage in beneficiary tax planning. This is a fairly high-level concept where you consider the taxable nature of the assets in your estate, and then you kind of operate within the rules to say, okay, let's say I have two kids and one kid is a high earner and the other one is a lower earner. Maybe I want to take pre-tax assets and tilt those towards the lower earner so that they end up paying less tax on those assets. And maybe I want to take the after-tax assets like a Roth IRA and tilt those towards the higher earner because they won't be taxed. And we're still treating each of our kids equally, but we're operating within the rules, the tax rules in a strategic way or an intelligent way. Well, if you have trusts and beneficiary designations set up properly, you can do that. If you're just leaving it to chance, that's not an option. It takes that option off the table. You can also create shares of trusts that can help reduce state or federal estate taxes. So a lot of times when people set up a trust, one of the things that the trust can do is it'll have the ability to set up something called either like a marital or sometimes called a bypass trust, where it will allow for the creation of a share of the trust to use any state exemption amount that might exist, an exemption from estate taxes. And if you don't have it, if you don't have a trust or you don't have that set up, then your estate eventually is going to get hit with it. So if you're concerned about your estate and the taxes that might be owed, I strongly recommend having a conversation about setting up a trust that can help with this. And finally, a trust can protect or hold assets for your beneficiaries, meaning let's say you have a kid who you love them, but they're not a very good financial decision maker. If you don't have an estate plan, that kid is just going to get a share of your estate. Maybe you don't want them to get it outright. Maybe you want it to be held in trust for a while to make sure that that child will be a little older. Maybe they'll be a little bit further down the line and a little more mature by the time they inherit something. Trusts can do that. So all of these things, all of these, these concerns that you might have, trusts can handle those pretty well. And finally, sometimes I will see situations involving, blended families where there's children from prior marriages, and maybe one spouse wants to make sure that something is left to their kids, but they don't want to skip over their surviving spouse. Well, a trust can actually hold assets in a trust, provide income to the surviving spouse, but then still preserve the principle of that gift for the children after the surviving spouse dies. So there's a lot of flexibility, a lot of interesting strategic things that we can do with trusts, and all of these things become more important in retirement because you spent your whole life building up your nest egg. Now, this becomes much more important in retirement because in retirement, you've got more skin in the game, right? So an estate plan, really, the way we view it, is it's part of your retirement plan. You spend your whole life building your nest egg, taking steps to ensure that your spouse, your children are provided for in the most strategic way and in the most logical way is really, really important for protecting and preserving those assets. In other words, a failure to plan can cost your estate a lot. And as an example, very, very early on in my legal career, I worked on a case involving an estate where there was a very poorly written will. It was not prepared by an attorney. It was something that somebody had scribbled out on a piece of paper, and they did actually have it witnessed. So they had two witnesses sign it, but the way that it was written was extremely, extremely vague. And the children and the beneficiaries, because it wasn't just the kids who were named as to inherit things, by the time the litigation ended, the estate originally would have been worth about $2 million, But because everybody lawyered up and started fighting, and all of those fees and costs had to be paid by the estate ended up being worth about $500,000, which means everybody got less than they would have gotten if they would have just agreed at the outset, or everybody got less than they would have gotten if there would have just been a well-constructed estate plan on the front end. The poor planning in this case cost about 75% of the estate, or about $1.5 million. So there's real risk here. If you don't want your beneficiaries to fight, if you don't want to leave things to chance, then the best and most strategic move is to have a well-drafted plan. So, in summary, here at Hendricks Wealth and Estate Management, when we are working with clients on their financial plans, we regularly ask about estate planning, right? Either we know, because we've worked with them for a long time, that they already have an estate plan and we're familiar with it, or if they don't have an estate plan, we will try to work with them to facilitate making sure that they get an estate plan set up and that their estate plan is working hand in hand with their retirement plan so that we can make use of every strategic advantage that we can. Now, if you don't have an estate plan, or if you want to talk about how an estate plan can fit into your retirement plan, please reach out to us for a consultation. This really is part of what we do with when we're working with folks. And here at Hendricks Wealth and Estate Management, our goal is to become your lifetime financial partner, and that includes everything. That includes your retirement plan, your estate plan, making sure that those two things are working hand in hand for your benefit, and for the benefit of your beneficiaries. So that'll conclude the presentation for today. We have a couple of upcoming presentations. The next one next week, my colleague Dan Leitner is going to talk about how your network shapes your net worth. And then after that, my colleague Jim Madel will be talking about how your spouse, could your spouse take over for you tomorrow? Meaning, if something happened to you, would your spouse know what to do? Both of these things are very important topics that I feel like would be beneficial to log into. If you'd like to reach out to us, please reach out. You can call our main office number at 847-428-3997. Our Florida office number is 941-308-9862. You can visit our website at www.hendrickswealth.com. You can email us, and I'd encourage you to call or email if you have any questions. Please feel free to reach out to me personally. I don't see that we have any questions, so I'd like to thank everyone for attending. If you'd like to register for future presentations or to see a list of past presentations, you can check our website too at www.hendrickswealth.com/events. You can see some things that we have coming up, or you can see recordings of prior presentations. So with that being said, I think we're going to conclude for today. Thank you very much for attending. We'll look forward to hearing from you, and I hope everyone has a great day. Thank you very much.